Dad, get back to Dad, give me your right hand from down here. Yep.
There's a few others you can believe the ones you don't want.
Yeah. See if they're okay. All right.
Thank you.
Thank you. Yeah. I see you're still not retired. You're never retired. No, you've been saying that for 3 years now. You're lying to the court.
Freddie's been saying that for 3 years. I've only been saying it for 6 months. I got him in here.
I don't think so.
What are we doing?
Oh.
We're gonna do Adrian Davis next.
Oh,
Oh, the judge real quick.
Okay.
Is he in custody?
He is not.
No, he's not. No, bro.
A very confusing set of facts. I'm hoping I can pull the factual basis.
Sure.
What do you got?
I like it when, especially when it's confusing, because I don't know.
I figured.
Yeah. Is Mr. White, is this the Davis case that Mr. White is on, or who's on Davis?
Yes,
Okay, so you must have gone to go get his client.
yes. We.
This is docket 25-5183-FC. People of the state of Michigan versus Adrian Davis. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barbucks, on behalf of the people of the state of Michigan.
Good morning, Your Honor. Toby White on behalf of Mr. Davis. Mr. Davis is with me at the podium.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you've had enough time to speak with your attorney?
Yes, ma'am.
And are you employed?
Yes, ma'am.
And what do you do?
DoorDash.
Okay. So did you graduate high school?
Yes, no, I got my GED.
Same thing, that's good. We're good. All right, good for you. Okay. And you're a US citizen?
Yes, ma'am.
And you are still living in Illinois?
Yes, no.
Oh.
I live on Lynn
Well, let me see if I've got that here. Oh, so Lynn, you've got that here on the,
Yes.
right? All right, very good. And who do you live with?
My wife.
Okay. Good. And at the time of this offense, were you on probation, parole, or bond on another file?
No, ma'am.
All right, very good. And you had enough time to talk with your attorney, I understand there's going to be a plea, is that correct?
Yes, ma'am.
Did anyone force, threaten, or coerce you into this agreement?
No, ma'am.
Anyone promise you anything other than the agreement?
No, ma'am.
You made a decision to plea of your own free will
Yes, ma'am.
after talking to Mr. White,
Yes,
and
ma'am.
you've been satisfied with his representation?
Yes, ma'am.
On behalf of the people, what is the plea agreement for the record?
Yes, Your Honor. The defendant be pleading to count 2, weapons, firearms, possession by a prohibited person. Upon successful plea and sentencing, count 1, count 3, count 4 will all be dismissed. And the habitual 4th will be amended to habitual 2nd offense status. There is an agreement in this case, Your Honor, where the parties agree that the defendant will be sentenced to cell F1 on the applicable E grid, which we have calculated at 9 to 28, with any upfront jail to not exceed 1 year. And the defendant agrees to and will receive a term of probation as part of sentencing. Any restitution will be determined at the time of sentencing. And it was not included, but obviously under statute, any weapons or contraband will be forfeited.
Thank you. Mr. White, all fair, accurate, and complete?
It is, Your Honor.
And you are in agreement, counsel, with the, it would be at F1 on the E grid, 9 to 28 months, regardless of how it comes out.
Yes,
If it's different.
yes, I agree with that stipulation, yeah.
Okay, and so you understand that that grid may be different, it may be higher, it could be lower, I have no idea, because they come out all different ways, and then we argue about it later, but the agreement is that it would be the 9 to 28 months grid. Does that make sense to you?
Yes, ma'am.
So here's the thing, is there's all these factors, and we're stuck with living with how they calculate these. So sometimes, as in your agreement, there's an agreement of counsel that regardless of how they come out, higher or lower, okay? I can only sentence between the 9 to 28 months if I give you to jail, okay? I don't have to give you any jail. If I do, there's an extra agreement that it cannot be more than a year.
Yes, ma'am.
Okay, so, and I just tell you that so you understand that if it's lower, because it could be, I don't know, 6 to 12 or something like that, and you might turn to us and say, hey, wait a minute, what happened here? This is just part of the agreement, and hopefully I don't have to give you any jail, but you have a right to understand up front that's part of the agreement regardless of how the numbers actually come out. Does
Yes,
that
ma'am.
make sense? Okay. Counsel, I stated that correct?
It is, you did.
Thank you very much. And counsel, are you waiving reading of 1, 3, 4, and the habitual court?
I am.
Okay. And I don't remember if I asked you, but sir, after having said all of this, you've been satisfied with the representation of Mr. White and you want to proceed with the plea?
Yes, ma'am.
All right, very good. On behalf of the people, ask to count 2.
Yes, Your Honor. People of the state of Michigan versus Adrian Keon Martrail Davis, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 2, weapons, firearms, possession by prohibited person, on or about July 23rd, 2024, at 812 Baker Street, Lansing, Michigan, 48911, Ingham County, State of Michigan, the defendant did possess a firearm and ineligible to do so because he or she had been convicted of larceny from a person, a specified felony. That is punishable by imprisonment for more than 1 year, and the requirements for regaining eligibility had not been met, contrary to statute. This is a felony that is punishable up to a maximum of 5 years and or $5,000 with mandatory forfeiture of the weapon or device per statute. As I stated, the plea is also going to be to a habitual offender second. Take notice that the defendant was previously convicted of a felony or an attempt to commit a felony in that on or about December 9th, 2009, he or she was convicted of the offense of possession with intent to deliver a controlled substance less than 50 grams in violation of 333.74012A4 in the 30th Circuit Court for Ingham County in the state of Michigan. Therefore, the defendant is subject to the penalties provided by statute, that being 1 1/2 times the maximum sentence or primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction, with the maximum count 2 being 5 years. That would make this 7.5 years as the maximum. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read? So you understand weapons, firearms, possession by a prohibited person normally is a 5-year felony, but because of the habitual second, it is 1.5 times. It's going to be 7.5 years. So
If I may, if you understand, that means that you're on probation and you violate that, the Department of Corrections could hold you for up to 7.5 years, but first you would have to create, you'd have to violate probation such that this judge ordered you to
Yes,
go to
ma'am.
prison.
if things go really wrong, you're subject to up to 7.5 years because there's that habitual.
Yes, ma'am.
Okay, hopefully everything goes right, but
Yes, ma'am.
it's a whole lot better than your mandatory 25 years.
Yes, ma'am.
Well, it looks like you all returned for a complete agreement, so hopefully everything will continue to go well. All right, and it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, ma'am.
Did you understand what you read?
Yes, ma'am.
If you had any questions, were you able to ask your attorney those questions?
Yes, ma'am.
Do you have any questions about your rights at this court?
You have to be audible.
No.
Okay, we're making a record, so I just need you to be clear in your answers, because if you want to appeal, if something goes wrong, the record that you appeal from is the record she makes, and she can't guess your answer. So I just need you to make sure that you, instead of nodding your head, you say a word, okay?
Yes, ma'am.
All right, very good. And counsel, it looks like, as to the dismissed counts, I don't know if you made a record of this, but if there is, first of all weapons will be forfeited. I don't know how many there were, there's a couple of other counts of firearms that were dismissed, but in regard to the count 1, if there's any restitution, that would still count.
And that is marked in the sentencing agreement.
Okay,
Or the
just wanted to
date.
roll that.
It was,
So, sir, in the event the victim wants restitution for any personal and property damage, and you disagree with the amount asked, then you let your attorney know, and we'll have a hearing, and I will make a decision based on the evidence. The amount can go up, it also can go down. And I don't know at this point if they're asking for anything, but they do have a right to ask for restitution. Do you understand that?
Yes, ma'am.
All right, very good. Sir, as to count 2, weapons, firearms, possession by a prohibited person, how do you plead?
Guilty.
And sir, the agreement is that I sentenced you. There's a cap of 1 year, so I could decree anywhere from 0 to 12 months. If I gave you prison time up front, then I would allow you to withdraw your plea in this manner, again, go to the pretrial stage. Or if I sentence outside the 9 to 28 months, if I gave you more than 28 months, I would allow you to withdraw your plea, because I would be violating your agreement. So if I do something that's not part of the agreement, you can withdraw your plea. First of all, do you understand that?
Yes, ma'am.
However, if you violate the law or bond conditions, it nullifies this agreement. I can do what I see fit. Do you understand that?
Yes, ma'am.
All right. Now, I understand there's some unique circumstances, and your attorney's going to ask you some questions to provide the factual basis for the count that you pled to, and then prosecutor or I may have additional questions. Do you understand?
Yes, ma'am.
If you need us to rephrase or repeat, please let us know. Mr. White, you may proceed.
Thank you, Your Honor. Mr. Davis, I'm going to call your attention to July 23rd, 2024. That's 2 years ago, almost to the day. And at that point in time, do you recall the location you were at?
I was on Baker, I don't know the address.
Okay. You were in Baker Street. Baker Street's in the city of Lansing, the county of Hingham, correct?
Yes, ma'am. Yes, sir.
Okay. And at that point in time, you had, as we outlined before, you had previously been convicted of a drug offense on or about December of 2009.
Yes,
And that meant that you were not allowed to possess a firearm.
yes,
You had not taken any steps to have your firearms, ability to have firearms restored.
yes,
And nonetheless, at that time, when you were on Baker Street, you did have a firearm in your possession for a brief time or whatever, but it was in your possession.
Yes.
You had control of the firearm.
yes.
Thank you.
And sir, if I told you it was 812 Baker Street, does that sound about right?
Yeah, you could. I don't know the address, but yeah.
Okay, our council stipulating to it being 812 Baker Street, so we don't have to amend the value information.
The people would stipulate, Your Honor.
I'll stipulate.
All right, very good. And you would agree that a firearm is a dangerous weapon?
Yes, ma'am.
On behalf of the people, any additional questions?
The people are satisfied, Your Honor.
All right, thank you. And sir, the firearm that you had, was that yours or was it somebody else's that you had in your possession but they lawfully had it or owned it?
There's somebody else's, no,
Did they lawfully own it as far as you know?
no.
Okay. If they did lawfully own it, if somebody else had a license to have that, they could claim it, but it's going to, any weapons and contraband found is going to be forfeited today.
Yes,
But I always make a record that if somebody, you know, if it was your grandmother's, your grandfather's, or I don't know, your neighbors, and they lawfully had it, they could go and claim it, but you can't. Does that make sense to you?
yes,
All right, very good. Are council aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Does court comply with the court rule?
You have, Your Honor.
You have?
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter counts 1, 3, and 4, and the habitual 4th are dismissed, and count 2 will go forward with the habitual 2nd and the amended information. Any outstanding warrants, if any, are hereby recalled and dismissed. All weapons and contraband are forfeited. The no contact order with the victim, Anthony Vandermoer, Vandermoere, will continue. And the victim was contacted and was part of this plea agreement, or at least there was an attempt made.
The people did contact the victim, Your Honor.
All right, thank you. And bring sentencing date.
September 16 at 9:30.
Does that meet with your schedule, counsel?
Being mostly retired, it should. Let me check. When is that?
September 16th at 9:30. Sir, can you keep your hands on your phone?
Thank you. That works, Your Honor.
All right, very good. So, sir, we're gonna give you that purple sheet there that has the sentencing date today. And you can also call if you don't have time today, but within 24 hours, you need to make an appointment with probation. But while you're in the building, if you would just go downstairs, hit G in the elevator, and
If I may, Your Honor, I'll
Yeah.
walk him down.
Great, and then you'll make that appointment there, and you'll need to keep that appointment. If you're sick or something, you need to change it, you change it with them, they
I'm
don't
going
care.
to consider basement probation.
Yeah,
Just to check in for
It's-
PSIR and the interview that they're gonna
they're
schedule.
gonna do an interview that has, it's a preset investigation report that has your background, and a lot of information about what happened. And that will help you be fully informed at the time of sentencing. You must do that. If you do not do that, then I have a standing order that law enforcement picks you up and they hold you in the jail until it gets done. So don't make that happen.
Yes, ma'am.
Okay, so go down, make your appointment, keep it. Something happens, you're sick or something, you change it. Don't just ignore it. Wait for them to call you.
Yes,
Do you have any
ma'am.
questions?
No, ma'am.
And you understand the no contact order with the defendant?
The defendant.
I'm
Yes,
sorry,
ma'am.
with the
Yes,
victim?
ma'am. Yes,
Okay,
ma'am.
is the victim someone you knew?
No,
Okay, so in that situation, if you didn't know him, but if you recognize him or he recognizes you like at Myers, you're just doing about face and leave. Just don't say a word, just leave.
yes, ma'am.
All right, good. Thank you. That's all for the record.
Thank you, Your Honor.
We're gonna do Devon Cheney next.
This is docket 24-1007 FH, people of the state of Michigan versus Devon James Cheney. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bar Bucks on behalf of the people of the state of Michigan.
Good morning, Your Honor. When I will be launching for Mr. Cheney, who's at the table with me.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes, Your Honor.
You put your hand down. Sir, have you had enough time to speak with your attorney about sentencing?
Yes, Your Honor.
Have you taken any medication, marijuana, alcohol yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
Yes, Your Honor.
And does that affect your ability to understand your attorney or this court?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And sir, you pled guilty to count 1, possession of a controlled substance known as cocaine less than 25 grams, that's punishable by 4 years short that.
Yes, Your Honor.
Have you read the pre-sentence investigation report?
Yes, Your Honor.
And if you had any questions about it, your attorney was able to answer those?
Yes, Your Honor.
All right. On behalf of the people, any corrections, additions, deletions?
A few corrections, Your Honor. The attorney throughout the report states Melanie Wanji. However, Attorney Wanji is only on this case as the time of sentencing. The attorney at the time of plea was David Carter, who I believe was retained. So I believe it would be appropriate to put David Carter as the retained attorney for plea throughout the report.
All right, so, and Ms. Wanji, you're appointed, correct?
Yes, Your Honor.
All right, so let me make that change in the basic information sheet. And I've made that on the cover page as well. And then the evaluation plan is,
It is correct on the evaluation plan, Your Honor. I do have a correction to the evaluation plan, however.
all right, okay, it is correct there, you're right. And what is that change?
On line 4 of the evaluation plan, it
Yes.
says public defender Melanie Wanji is not representing the defendant. I believe that should say now representing the defendant.
Okay, thank you.
And then no other changes to the body, Your Honor.
Ms. Wong, do you need additional changes?
Yes, Your Honor, on the basic information for, my client, it stated that he highest grade completed, it's 11th grade.
Yes.
I think that he just graduated with an associate degree from
Oh.
LCC.
Yes, okay, so let me change that throughout, because it says 11th grade throughout, so very good. All right, so where did you get your high school diploma or GED?
My grandmother completed it.
So did you do a combined program at LCC?
yeah.
Okay, so, how'd you like that program?
It was very, I like learning new stuff.
Good, I hear good things about it, so it's good that you can do both. So you've got, high school, and so are you going on to school or no?
Yeah, I wanna go for the masters
Great,
since they offered me to.
that's great. At Michigan State or?
No, LCC.
Oh, I didn't realize you could go do that.
Yeah, they said I could go back and get the masters.
Great, okay, very good. So I've noted that. When did you get that degree?
The 21st, June 21st.
Oh, new graduate, congratulations.
Thank you.
Okay. I've made a note of that under education. Is that anywhere else, other changes?
I don't think so, Your Honor.
I guess my only other question in regards to education is when was the start date for LCC?
February. It was actually January when I got released.
January of this year?
Yeah.
And then what was the area of study?
Business.
Thank you.
Okay, thank you. All right, and as to the guidelines,
You know, there was another change just after on the same page, on the dependent. It stated that he only has 2 dependents, actually 3.
I'm sorry, where are you on the,
Same page, the basic information report,
okay,
just after the education. On the-
oh, okay. Okay,
And I think the last one that I have is on the pre-sentence investigation report.
so how many dependents does he have?
He has 3.
3, okay. Okay, and then,
The first page of the pre-sentence investigation report regarding the cocaine use. It would be correct to say that he stopped using in 2024 after this incident.
changing the August 31st, 2022 to
24.
17 October 24.
Thank you.
And that would be on the cover page as well as probably somewhere in the. There, let me just see. I'm changing the end date on page 13 as well, so it's consistent. to 17 October 2020. And then do we need to change family? It says, oh, he has,
I see all three listed. there,
oh,
Your
3
Honor.
children, okay, 2-year-old and a 1-year-old, okay, very good. All right. Any other corrections
No, Your Honor.
as to the guidelines?
Yes, Your Honor. OB 12 is currently scored at 1. OB 12 is in regards to contemporaneous felonious criminal acts. The case that was ultimately dismissed was a resisting obstructing a police officer, which is a person crime. So I do believe that OB 12 should be scored at 5, which states 1 contemporaneous felonious criminal act involving a crime against a person was committed.
That's correct.
All right, OB 12 is 5, that's a total of 15. I don't think that changes the level, does it?
I don't believe so either, Your Honor. Let me just double check that.
Okay, and I'll change that, the basic information sheet.
It does not, Your Honor.
Thank you. Change that. The narrative, and I don't need to correct anything there. All right, great. Do we have any victim who wishes to address the court?
No, Your Honor.
All right, we have the people, what would you like me to know?
Yes, Your Honor. I would just ask that you follow the recommendation of probation. Thank you.
Thank you. Ms. Wanji,
Thank you, Your Honor. You know, I would ask that the court follow the recommendation. Just want to also ask that let the court know that he was released in June to allow him to get out of jail so he could participate to his graduation. And he's very thankful for that. He said that it was one of the best experience in his life. I know that my client has some pending charges coming with this court, and however, you know, since his release, it's my understanding that he's been compliant with the order of this court. He's been calling critical services. There is no, he has not violated the conditions of the curfew. And I think that the graduation, or allowing him to go to the graduation, has been something that clicked with him, and he has plans for what he's going to be doing once he's on probation and have taken care of the pending charges. So we would request to ask the court to follow the recommendation at this time.
what are the pending charges? Counsel?
I see 2 cases, Your Honor. One he was just arraigned on last week in front of Your Honor, which is set for a fleeing third and a resisting and obstructing. And then the additional count that was just bound over from district court on the 14th of this month are 2 counts of financial transaction device, steal/retain without consent.
Okay. Thank you.
That looks like it's a habitual 4th on both of those, Your Honor.
Okay. Thank you. Sir, what would you like me to know without talking about the other cases?
I would like you to know, Your Honor, that I do appreciate you at giving me another shot out of jail, because in there, I don't honestly meet the needs in there, like with myself. I don't really know how to get my mental health under control, and that's what I'm trying to do now. But other than that, since having another shot at life, I've been able to go to school, participate, doing different stuff in the community, instead of just running the streets, being in the streets, doing nothing, doing drugs, you know, hanging around bad influences. I'm honestly growing up. I'm now 23. My birthday here in about 5-6 months. I'm trying to get it to where I can do something nice for myself, because I ain't been able to do it. I've been in jail repetitively the last 4 or 5 years, and it ain't been fun, and it's been challenging, honestly. And I don't want to keep making the same mistakes, but I do honestly take all full accountability for what I did, what I have done, and I want to make changes. I don't want to keep going down the same road because my kids is getting older. I have a soon to be 6-year-old here in September, and he's getting older. He knows what's going on, and I'm just now getting into where I can be in his life more because I'm getting on the right path, and I'm getting better opportunities with changing my life, what people wanted me to do because I wasn't going down the right path. I've been living a fast life because I honestly ain't got parents for real in my corner. My dad just died. I got 7 little brothers. They wasn't able to make it today. They live in Detroit because they had to get up out of here because of a lot of violence and stuff going on. But in all reality, Yana, I started a business. It's a cleaning business. I started it a couple years ago, but was never able to really get into it because I was busy doing other dumb stuff, doing drugs, hanging out, wasn't really focusing on my kids, was really saying F them because I wasn't participating in their life. And that's what me and their moms is going through now. I know they ain't really got nothing to do with you, but I'm just trying to better myself. And if probation is something that can help me, when I did get my PSI done, I was talking to them about stuff that can help me with therapy I can get into because of my PTSD, which is certain stuff that's causing me to react the way I do, stuff that I need to get control of. And if it's up to me, I'm gonna do whatever it takes to do it without having to be disciplined in an area where I'm with guys that don't care about me, that I'm always in jail, and I'm on the phone acting like, I'm sorry and stuff like that. It gets old. And the last time I was really just in there, it made me realize, even with you, the way you talk to me, let me know how I should do stuff and grow up and be a man. I'm really coming to my senses because I don't see myself in prison or nothing like that. I got too much, like, I got potential, if that's the word I'm looking for. Like, I'm really trying to get it going for me and my little brothers. They all getting older. I got the cleaning business. I'm trying to get it. I already started it. I've been doing jobs and stuff like that. That's how I've been paying for my tether and stuff like that. And yeah, I've been doing better with my agreements on my dad. I've been going to see him more. It's been helping me. I ain't been drinking. I ain't been using drugs to cope with it no more. I honestly been trying to be a family man, trying to switch it up instead of being in the streets hanging out. I ain't been doing none of that. I'm switching it up, you know.
Who are your brothers living with?
My biological mom.
So is that, because it has your mother living in Lansing, but your brother's living in Nevada?
No, that was supposed to say Lansing.
So they're all living in Lansing?
Yeah,
Okay, I'm gonna change all that.
Detroit. Well,
That
Detroit.
doesn't go
I'm
to
sorry.
Detroit, okay.
Yeah.
So Messiah's living in Detroit
Messiah, yeah, all my little
and
brothers.
Kishan?
Keyshawn, yep. Yes.
Okay. And then you said your child now is 6 years old. I have your son at 5 years old. Should that be changed?
No, he's gonna turn 6 here in September,
turn 6,
September 5th.
All right, so are you paying child support for these 3 children?
Yes,
And they're 3 different mothers?
3 different mothers, yes.
Okay.
And it's kind of been difficult.
Huh?
It's been a little difficult, but we've been making it happen. I've been there
Okay.
as much as possible.
I appreciate you wanting children, but you were you raised in a home with a mom and a dad?
Yeah, it just it wasn't the same setting as a lot of other people's. It
Okay,
was a little rough, but
so,
I've been trying to make something out of it.
okay, so I just want you to think about that, because ultimately, you have 3 children with 3 different mothers, and you're not in the home. Okay, so history repeats itself unless you stop it now. So it's called abstinence. Using a condom.
Yeah.
You can have as many children as you want, but maybe you ought to wait till you have a stable relationship with a woman. You don't have to get married, but maybe you want to stay with her. A lot of people stay together that are married, and then be in the home with your child. Because you've got to, when I look at your history, I understand your PTSD and your grief and all of that. You've got quite a history. However, if you want to break the chain of that, you have to take some actions in your personal life. Be accountable to the women you date, to the children you create, to your community, to yourself. You were born to greatness. No one's born to crime. Everyone is born to greatness. That is what I believe. And you have choices, and I think finally you're making the right choices. But you gotta make good on those choices. So continue your education, keep doing good things in the world, because your children, in this day and age, they can just get on the computer. Your children can get on the computer and see how many times you were incarcerated and what you did. And as they get to be teenagers, and I have 5 kids, so I know what I'm talking about. Teenage years are horrible. And you're just getting through yours,
Just,
right?
Yeah.
So your kids, when you say, you gotta be home at 10 o'clock, don't run the streets, don't play with guns, don't do this, don't do that, they're gonna say, well, you did it, Dad. So what's your response gonna be, sir?
man, it's not gonna be pleasant. It's not gonna be pleasant because he
Well-
wasn't, he talking back to me like that. But yeah, no, I know where you're coming from, Your Honor,
So-
because I kind of did.
Yeah, you did it, but
I did
here's.
it in a way.
Here's what I want you to think about. I don't want you to be down on yourself. Okay, you got great potential, you got plans, you're finally thinking. I mean, if you look in the back of the room, there's none of your friends here, right? Because they weren't really your friends, there's nobody here.
I don't even care.
Right, so you gotta be your own best friend first. You've got to choose wisely your friends. In the world, we generally only have 1 or 2 really good friends that stand by you. And those friends need to be stellar because there's going to be an effect on your children. So when your children throw up in your face the things that you did poorly, you just own them and you say, those are teachable moments. They didn't define me, here's what I learned, and pass on the lesson. And if they wanna go to the school of hard knocks like you have, that will be on them too. But each of these things happen for you, not to you. And how they happen for you is because you have a lesson that you've learned. And finally, sir, I see it in you. You have a light. You can see, you have potential, you're going for it. You're gonna rise above all this. So I hope that you continue to do that and you are a shining example for the community, your friends who are still running the streets and doing the wrong things, and your children. Because if you don't rise above, I got a prison. And they'll gladly save you a bed. Do not make this a story about letters to prison to Dad. Do not make this a story about your children visiting the graveyard and looking at the headstone. Oh, Dad, they wish they knew. These are all decisions you have to make. And again, these are all teachable moments. So when you rise above them, it's all good. Everybody has a past. It's what we learn that makes the difference. Do you understand?
Yes, no. I do.
Okay, so, sir, I don't know about these other cases. I'm not gonna worry about them right now. I'm gonna put you on 9 months probation. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. As to any psychotropic medication, you will take that as prescribed. We can test you for illegal drugs, or we can also test you if you are prescribed psychotropic medication. We can make sure that you're taking it at the level as prescribed. Okay, I don't know what's going on with you, but let's figure that out with some therapists and doctors, so you can get through all of this. You're going to work with community mental health or whoever else you choose to work with in that arena to help you with your PTSD, your grieving, all those things. You need to go to a grief counselor, one that also looks at cognitive behavioral and addresses all your matters. So you work with that with the probation and see who you're gonna work with. And then you'll need to show up at all appointments and sign all necessary releases. As to the releases, we don't ask. I'm never going to a normal probation ever ask, what's he talking about in therapy? All we wanna know is, are you attending? Are you participating? Are you following the recommendations? Okay?
Yes, sir.
So this is to help you. Probation is not a punishment. It might feel like a punishment, but it really is to help you. Jail or prison is the punishment for not complying with the orders of this court. Do you understand?
Yes, sir.
You'll continue to follow all family court orders, including paying child support. And if you are positive for any substance that's not prescribed, a secondary test will be done to make sure it's not a false positive, and then you'll be brought before this court unless perhaps I recommend immediate residential treatment, depending what's going on. Okay, I don't know that you need that now, it's been quite some time since you've used, but if you decide to go backward, then I'm gonna know that you need some residential treatment to save your life. So stay away from the drugs, ask for help when you need it. Asking for help is a sign of maturity and growth. I'm not going to take, you're still on tether, right?
Yeah.
I'm not gonna take that off until we look at the other cases, but at the time, Ms. Wanji, are you representing him in the other cases?
I think so, Your Honor.
Okay, well, whether it's you, and if not, it's probably someone from your office,
Someone from- Yeah.
I'm not gonna take the teller off until those cases come before this court and look at resolution. And then I will certainly consider that. He's been on it quite a long time. I don't think I have a whole bunch of violations here. I think he's done really well, but since there's those other pending cases, we're gonna wait. So you will not change your residence unless you first obtain written permission from probation. You'll not leave the state without permission of this court. You'll not engage in any assaultive, abusive, threatening, or intimidating behavior. You will obey all recommendations of all treatment providers, court orders, and probation. All those are orders of the court. You'll contact probation today. Just go downstairs and make and keep your first appointment and all subsequent appointments. You'll allow probation into your residence at any time for probation supervision without a warrant and subject to a search of your person and property, including but not limited to your vehicle, cell phone, residence, and computer. If probation has reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest, police contact, personal protection order, place on you, loss of employment, or change of residence within 24 hours. Weekends and holidays are exceptions. So if something happens on Friday, tell us on Monday, Monday's a holiday, tell us on Tuesday. And you are still employed, correct?
Yes, sir.
All right. If at any time
I'm
you're not,
self-employed.
yes, but if at any time you're not employed, then you'll be part of a work seek program. So if things aren't going well, you want to close your business or whatever, just let us know, you'll be part of a work seek program. And you're making enough money to support yourself.
Yeah, it's a little slow right now, but
Yeah.
I'm getting it going.
All right. You'll serve 365 days jail with credit for 89 days served. The balance is held. We can use any or all that time while on probation. You'll pay a crime victims assessment amount of $130. I'm waiving probation oversight fees, finding you're indigent for that. And you'll pay a $68 state cost, that's $198 is owed. Just go on a payment plan, I don't care if you pay a couple dollars a week or whatever, just get that paid by the end of probation, but probation will not be held open for that money. If you end up using marijuana, it would be by prescription and only as prescribed, same with alcohol, and you'll need to keep us informed. You'll not use any objects or weapon. You shall not own, use, possess, or be in the presence of anyone who has a weapon of any kind, and that would include any contraband, alcohol, illegal drugs, drug paraphernalia, etc. If you walk into someone's house, they have contraband, you just do it about basically leave. They may not get in trouble, but you will get in trouble. This has a recommendation of 180 days curfew monitoring tether. I'm not going to do that. I'm simply going to put that we'll review the tether upon resolution of the pending cases. I don't know that he needs to be on tether for another 180 days. He's been doing really well, so we'll take that as it comes, okay?
Thank you, Your Honor.
Is there anything I missed?
No, Your Honor.
No, Your Honor. The
All right.
appellation.
You have 42 days to appeal to request appellate counsel. Is acknowledge your appellate rights, sir?
No.
Yeah.
Wait, what's this?
That's your appellate rights. So if you're not happy with this, you have 42 days to appeal, okay? It's up to you. All right, I just have to give it to you. So I need you to go downstairs and make your appointment with probation. If there's anything at all, you have problems, don't just ignore them. Let your attorney know, let probation know, and if you don't get the right answers, let me know and I'll call everybody and we'll get it handled. I expect great things from you, sir, and I want you to expect them from yourself.
Okay, ma'am.
Thank you.
Yes, ma'am.
Thank you.
Thank you.
Thank you.
Appreciate it.
Thank you.
We're gonna do Dakota Morales next.
Can I run to the restroom?
Yes. It'll be just a moment.
It doesn't look like running.
What are we doing?
We're gonna do sentencing on Dakota Morales.
It's better to be in between that. I feel like it's always worse when you're like sweating. Mhm, yeah. Yeah. I'll just go after somebody. She cut me in.
Well, just one line, just one line.
I can help.
I'll give you my office.
The other one is I can't get the light to go on.
Okay, you're all just welcome to do it. Do I get over it for a minute? Okay.
No, I'm
Okay.
good. That was just when I used to go to the bathroom, I was trying, you know, to take the bathroom.
Just 20 seconds.
Which one are we doing?
Morales?
Where's that one at? 10:30.
Okay, before.
I got it. Thank you.
This is docket 25-1322 FH. People of the State of Michigan versus Dakota Morales. Counsel, your appearance for the record.
Good morning, Your Honor. EPA Barb Buxton on behalf of the people of the state of Michigan.
Erin Robinson, Assistant Public Defender for Mr. Morales.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Raise your hand down. Sir, you pled guilty to weapons carrying concealed attempt, which normally is a 4-year, but because of the attempt is punishable by 2 years. You recall that?
Yes, Your Honor.
And sir, have you taken any medication yesterday or today?
No,
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had an opportunity to speak with Ms. Robinson, your attorney?
Yes, Your Honor.
And you reviewed the pre-sentence investigation report?
Yes.
And you remain satisfied with the representation of Ms. Robinson?
Yes, Your Honor.
And on behalf of the people, any corrections, additions, deletions?
The only change I have, Your Honor, is on 7 of 7, so the instant offense in this case is criminal history. The sentencing date is listed as 7/28, but today is 7/29, so I would ask that get changed.
We have no objection.
Okay, let me see, did they get that right in the,
I see it right everywhere else, Your Honor.
okay. Yeah, you're right, it is right everywhere else. It's just- Okay, that change has been made.
Actually, I apologize, on the evaluation and plan, it also is incorrect at the bottom of paragraph
Paragraph what?
Oh, yeah.
1.
Yeah, they have 3 different dates in here. Okay. Okay, I've changed it.
And that is the only change that people have to the body or the guidelines.
We have no changes, Judge.
All right. What is the recommendation of probation? What would you like me to know?
I guess, Your Honor, I just asked that you follow the recommendation of probation. Thank you.
Counsel?
Your Honor, we would ask that you follow the recommendation of probation as well, but we would ask that you reduce the probation term to about 12 months. And the reason why I ask that is because Mr. Morales has already taken some steps in order to better himself. He's doing great. He's got, he is in charge of supporting his family. taking care of sick family members. He's been employed with the same company for a long time now. The social worker at my office was able to speak to his boss, who gave glowing recommendations about Mr. Morales. He has a very limited criminal history. This is his first felony offense. I don't believe that he's a danger to the community, so we would ask for a term of 12 months of probation.
Thank you. Sir, what would you like me to know?
There's so much you want to say, but there's.
So what have you learned from this, sir?
Well, I learned that it was a stupid mistake. I really don't ever want to do this again. I got so many people depending on me, need me. And it's really like, I was telling my attorney yesterday, like I don't wear designer clothes like everybody else. I'm always working. I'm in work boots and, I'm work clothes now. As soon as I leave here, I gotta go make some plumbing. But, yeah, it's just a mistake and I definitely don't want to do it again. I'm just, trying to move forward. Next year I'll be opening my own business. I'm getting ready to go buy some lawnmowers, some zero turns, and getting help from another family member to support me in that. So I'm excited about that, and I really that's really it. Like I just want to move forward and just take care of everybody that's closest to me. I don't walk the streets anymore. I don't do anything like that. I don't do drugs, so.
So have you taken a weapon safety class?
I haven't. My whole thing before this happened, I was actually going to go take a CCW class, and I wish I did it sooner, but it was just at the time I didn't have the money and timing really. So this was like I was joking with my cousin, not really joking, but like telling him like I wish I was just found some way to get that done. This wouldn't be happening right now, So
Okay.
it's a mistake all the way around.
Well, I think it's smart to not wear designer clothes. I don't wear them either. My philosophy is that I don't want to pad somebody else's retirement. I'd rather pad my own, right?
Right.
All right. So, it looks like you are doing well. So here's what I'm gonna do. I'm gonna put you on 3 months probation.
That's
During which time you will not use, possess, consume, purchase alcohol, illegal drugs, drug paraphernalia. You'll have no weapons. You'll not use any object as a weapon, no ammunition. You will take and complete a weapons safety class. Counsel, you can explain to him there's one that's a lot of people use on the computer. You have to pass it, and there's a little certificate that comes up, and you can explain that further. You got 3 months to sign up for that. Don't wait till the last minute, because I can keep you on probation for 5 years if I want. I can send you to jail or prison if I want. Don't make me do anything else. I don't think, you don't have the worst record I've seen. It seems like you've learned from your mistakes, but this is your first felony.
Yeah.
Don't make this grow.
Yes, right.
This is big enough now. You got family, you got goals, you got business, you got a lot going on. So these 3 months will tell me a whole picture. Either you are remorseful, rehabilitated, and you'll stay on the right side of the law, or you'll go down the other path and the jail and prison await you. And I don't care about sob stories, because you will have shown me your true colors. I do believe everyone's born to greatness. You're just finding yours. Keep moving on that path. Don't go down the dark alley, because that leads to prison.
Yes, sir.
You will pay a $68 state cost and $130 crime victims. It's a total of $198. I'm waiting probation oversight fees. You'll notify probation of any arrest, police contact, personal protection order placed on you, loss of employment or change of residence within 24 hours. So if something happens on a Friday, tell us on Monday, Monday's a holiday, tell us on Tuesday. You will maintain your employment if at any time you're not employed, you'll be part of a work seek program. You'll allow probation into your residence at any time for probation supervision without a warrant and submit to a search of your person and property, including but not limited to your cell phone, vehicle, residence, and computer. If probation has reasonable cause to believe you have items that might violate the conditions of your probation. You will not engage in any assault or abusive, threatening, or intimidating behavior. You will not change your employment or residence without written permission of probation, or leave the state without permission of this court. You will serve 365 days jail with credit for 2 days. The balance is held. You will not own, have in your possession, under your control, the imitation of a weapon, ammunition, any weapons at all. The weapons in this case and any contraband and ammunition were forfeited already, so we've taken care of that. Anything else I need to order, council?
No, Your Honor, thank you.
No, Your Honor.
This is pretty minimal, sir. Follow the law. Meet with probation once a month. Take your class, pay your fines. Don't get in trouble again.
I'll sign it tomorrow.
You got 42 days to appeal to request appellate counsel. You acknowledge receiving your appellate rights.
Yes, Your Honor.
Counsel, if you could show him probation, so you can make his
Yes.
first appointment. This will be over before you know it, as long as things go well, sir. All right?
Yes, Your Honor.
Good luck to you.
No, I appreciate it. Thank you, Your Honor. Have a wonderful rest of your day.
Cortez Boyd.
You want to take that, right, Nancy?
Yes, unless someone else needs it.
Go ahead, go potty, Nancy. I gotta grab the file.
Boyd.
It'll just be a minute. It's just a moment.
Is this the press part?
No. Or I apologize, actually it is.
That's why I asked.
I apologize, you're correct.
That's why I asked.
Control.
Got it.
See his attorney here. All right, this is docket. Just one moment. On the order, it says 1687.
Yep, 1687 MC,
Okay,
right?
yeah, but on the application, it says 20, oh, I got it, 2016-87. Okay, I'm just gonna add it. I got it. It's just the FC missing. Okay, we're good. This is docket 16-87 FC, People of the State of Michigan versus Dennis Molitor. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buckton on behalf of the people of the state of Michigan.
Maria Shaya for Mr. Molitor. I am a Michigan State University law student under the supervision of Emily Brule, requesting a permission to appear under Michigan Court Rule 8.120.
Granted.
What was the court rule?
8.120.
Thank you.
And Mr. Molitor, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. This is an application to set aside conviction. There was one charge. The date of conviction was November 2nd, 2016, unarmed robbery. On behalf of the people, have you reviewed the file, the Attorney General letter, and the state police records?
Yes, Your Honor, the people have received all of that documentation. The AG letter states that Mr. Molitor appears to be eligible as long as his circumstances and behavior warrant a setting aside of the conviction. The people will ultimately leave in the court's discretion. Thank you.
Thank you. Counsel, the people have no objection. Is there anything you want me to know before I turn to your client?
Yes, Your Honor. Mr. Molitor has clearly rehabilitated himself since the time of his conviction. He is a devoted father of 2 children, and he remains actively involved in their lives, providing both emotional and financial support. He has worked diligently to build a stable and productive future for himself. Mr. Molitor is currently employed full-time at LG Energy Solutions, and since his conviction, he has graduated with an associate's in business, completed an electrician apprenticeship, and received certifications for electrician and computer skills. Mr. Molitor seeks an expungement so he can secure more stable employment as an electrician, as his criminal record continues to limit both hiring and licensing opportunities. His conviction has also prevented him from securing housing in the past. Overall, Mr. Molitor hopes to put this chapter behind him so he can better provide for his children and build the future he worked so hard to achieve. I would like to now take the time to read an excerpt from his letter of support. Dennis is a natural leader who leads by example. The workplace is genuinely a better, more collaborative environment because he is a part of it. Dennis has completely transformed his life, demonstrated accountability, and proved himself to be a law-abiding, contributing member of society. Thank you, Your Honor.
Thank you. Sir, what would you like me to know? What have you learned from all this? It's been a long time.
Yeah, it has been. What I wanted to say, but I recall that on the day of my sentencing that you told me that this wasn't the end for me. But then, I was 19 and I didn't want to live up to other things I was doing. But I came to realize that prison actually saved me because I was going down a terrible, terrible path. And since then, I did nothing but change my ways, change my thought process. I've tried to accomplish everything I possibly can and just get out of trouble. And I really just want to get this scarlet letter finally removed from me. It's been so long. I'm 31 years old now. I just want to move on from this.
Yeah. Well, I appreciate you recognizing probably incarceration saved your life.
Yes, it did.
And you know, I hate sending young people to jail or prison, but sometimes I have to take them out of the community they're in so that all their bad friends move away and you see the light and you do better and you stay alive. And so I appreciate that you recognize that this happened for you, not to you, and you learned from it and you've done great things since. You know, you're raising two kids who can look up to you in terms of especially your accountability and changing the path that you were on, and we really can't ask more of you than that. And you certainly have risen to meet your potential and you will continue to rise. So I truly appreciate and congratulate you for that, and I'm granting you this set aside. An
Thank you so
application,
much.
an application is set aside. The following conviction was filed on May 20th, 2026, unarmed robbery. And the court finds Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for assault of crime set aside pursuant to the statute during their lifetime. There are no criminal charges pending against the applicant. The applicant has not been convicted of any criminal charge during the applicable time period required under the statute. And the applicant is requesting that a felony offense punishable by more than 10 years imprisonment be set aside, and the applicant has not previously had a felony conviction for the same offense set aside pursuant to the statute. The time period for the conviction listed in item 1 has passed. And an opportunity has been given to the Attorney General, prosecuting official, state police to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application more than warrant and justify setting aside the convictions, and it is consistent with justice and public welfare. Therefore, the application is granted as to the conviction listed in item 1. Pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence in the case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read, dated, and signed in open court. Sir, if you were here, I would ask you to approach and hand you this personally and shake your hands. I'm doing it virtually. The last order of this court is that you take your lovely family out for a celebration dinner, because you certainly have earned that, and so have they, by the way. So, you know, continue to do great things, celebrate this. It really is a monumental occasion. Not everybody reaches what you have done. So congratulate yourself every day, but go out and celebrate, okay? That's an order.
Of course. Thank you so much.
Now, I don't run every department. Some days I wish I did. It might be easier, but I imagine it will take, I don't know, 3 or 4 weeks, possibly, maybe less, hopefully not more, to get all of the departments to get this expunged or set, you know, put in their records the right way. But if you find that it takes longer than 4 weeks, counsel, please contact me, and then I will make a phone call on his behalf to make sure that is done. So far, I haven't had to make any calls. They've been doing what they're supposed to do, and during COVID, it was taking, you know, 6, 8, 12 weeks, but now they're much quicker. So hopefully that all gets done. We're gonna send you all a copy of this. That is all for the record. Good luck to you and congratulations.
Thank you so much, Your Honor.
Thank you.
Thank you. Mr. Anthony, Carlos Anthony.
We'll do William Townsend next.
It starts out, it's being recorded.
Yeah.
That's just wonderful. Thank you.
Sorry, I missed that. Who was it?
William Townsend.
Just keep it. Yes, it's that your turn, stand up next to me. Thank you. All right, this is docket 256029 FH, People State of Michigan versus William Henry Townsend. Counsel, your appearances for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Mayor. Please, this honorable court, Kareem Johnson, appeal on behalf of Mr. Townsend, speed number 71988.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand out. Have you taken any medication yesterday or today?
No,
Are you supposed to be on medication you're not on?
no,
Any sign of fever, cold, or other illness?
no,
And you had an opportunity to speak with your attorney?
yeah.
And I understand this is being filed pre-trial on behalf of the people. Is there an offer?
So, Your Honor, I wanted to discuss that briefly. Mr. So we have not received the preliminary exam transcript yet on this file.
When was that requested?
So let me kind of explain. It was requested back at the previous hearing. However, apparently there has been issues in regards to the deposit. I just had a chance to talk to defense on this, and it's my understanding, because he is conflict counsel, he is attempting to go through to PD's office right now to file for indigency, to get the money to be able to request that transcript. It sounds as if they may also be requesting an expert at this time. I'm not quite sure exactly what that's in regards to.
Does that go through the PD's office or us?
Yes, Your Honor. First, I'm retained, Your Honor.
No, you are retained.
Yeah,
I
so-
apologize.
Okay.
Asking, and all of the people are, this is my fault, yeah.
Okay.
This, if it wasn't for my trial schedule, this would have been done previous to today.
Okay.
I'm
So,
asking the PD's office to declare him indigent. I was actually retained by his mother. Once he's declared indigent, if he's declared indigent, they will pay, and it's actually 2 sets of transcripts. It is the preliminary examination transcripts that we are requesting, but there are transcripts from CPS hearings in which the complaining witness and the detective in this case testified to the court. Furthermore, there was a expert testimony presented at the preliminary examination through one of the detectives regarding cell phone triangulation, but specifically the length or the area in which each tower's radio would pick up a cell phone and under what circumstances it will bounce from tower to tower. Now, based on prior trials, I think that he is wrong. So I am asking for my own expert, and as I've explained to the public defender's office, I'm not just trying to waste money here. I just, based on my experience, think that he is wrong.
so are you on the Catholic Council list?
I am, but I am retained in this case.
Okay, but. Okay, as long as that's good, I don't know, it gets really dicey when you request some of these things and then since you're retained, but he should be found indigent because somebody else is paying your bill. If that becomes a problem, let's all chat and see if we can do an order or see what we can figure out so there's no further delay, because there's some stupid rules that follow that.
Yes, sure.
Okay, because it'd be one thing if he was paying your bill, but if someone else is and he's indigent and it just becomes murky and it shouldn't be, because he's indigent, he's entitled to all of that. So if I can help, so we can speed this along, let me know. So how much time do you think we're gonna need?
We're asking for the court to reset this matter to September 10th at 2 p.m. It's my understanding that the trial, we were gonna get bumped from the trial anyway, because the court has a trial that's gonna overlap.
Okay, so do you think September 10th is long enough to get what you need?
Yes, Your Honor, when I was at the Jackson County Public Defender's Office, we did this all the time. It took less than a day. So I don't know what process the Ingham County Public Defender's Office has, but.
It's not a day.
Okay,
We're lucky if it's a month.
all right.
So let me just say this. I don't generally allow final pretrials to be moved, but I'm going to make a note based on what you just told me that you can move it one time without me. So if you can't get what you need by September 10th, you all can go back without my permission and get a new date, as long as the two of you agree on another date, not in 2027, but something reasonable depending on the circumstance. If you need my help, let me know. So I'll make a note that you can move it once based on this, because we're not as quick as other counties. Is there any issue with bond that I need to be aware of?
Not in regard to the people, Your Honor.
Not from us, yeah.
Okay, so sir, you'll need to be here September 10th at 2 p.m. Bond and bond conditions are continued, and that would be for our final pretrial. So there's going to be information you'll need to review with your attorney. I don't know if the people are making an offer or not. I don't get involved in any of that. And so you all will have to have some conversations, so make sure that you keep in touch with your attorney. And then I'll see you September 10th, or if it's moved to another date based on not being able to get the information that you just told me, because that's quite a bit. And it's being summer and people are taking their last vacations, who knows what's gonna happen. So that's why I said that. I just don't want to cause further delay. Is there anything else I need to address?
No, you're not.
Just to make sure, September 10th at what time, Your Honor?
2 p.m.
2 p.m., thank you.
Yes,
All
sir,
right,
thank you.
thank you, that's all for the record.
Is there anyone on Zoom for Carlos Anthony?
Yeah, the AG's offices, but that's it.
No Ron Berry?
No, Ron.
Okay.
Okay, is Ron?
Ron is on Carlos Anthony, yes, on both Carlos Anthony
You want
files.
to call, have you talked, sir, have you talked to Mr. Berry?
I have not, Your Honor.
And I've not heard from him either.
Okay, we're gonna, and where's the defendant? Is he in lockup or where?
Yes, this is a bench warrant arraignment, Your Honor.
Well, I can certainly arraign him and we can deal with it later. Do you want to reach out to Mr. Berry? Maybe he's in the building and in front of another judge?
I can go check, Your Honor.
While he checks that, do you want to call?
Yeah.
Okay. Sorry for the delay, counsel. We are going to see if we can find Mr. Berry. Otherwise, what I'll do is just simply arraign him and we'll set a date when counsel can show up.
Thank you. I'll stand by.
All right, thank you. So who else have we got?
Regal.
What about Evans?
He's still downstairs. He has not seen an attorney. I can have him brought up.
Who's his attorney? Because they've got a motion to modify bond. Sarah Donnelly, isn't she here?
She is, Your Honor, she is second chair on the matter that was down in JMO with the.
Both Starks and her are down there, and those are Riddle and Evans.
Correct.
Okay, so what is she, are they still on the record?
They just finished, Your Honor.
Okay, well, we could bring it, we could do that.
Riddle is up. If.
Oh, she's got to go talk to her.
ASA, no, Riddle is up, the other guy.
Does she have to talk to them?
Riddle is Starks. So
Okay.
Starks can come in here right away, and I already have Riddle up. We can get him done right away, and Sarah can run down and.
He is running around here, I do know that.
I will grab that. The Regal, right, Regal.
Kareem Johnson is reaching out to see if he can get in touch with Ron Berry. He is not here in the courthouse. Yes. Okay. No, I get that. Alright. Can you bring up Riggle?
He's up.
Oh, perfect.
He's been sitting for hours.
So high.
We're gonna handle Riggle.
My apologies, Your Honor.
I'll be on Zoom in like 5 minutes.
Okay. We're gonna handle Riggle first.
Apologies for my tardiness, Your Honor.
Okay, I know you were done, like we had a choice.
Well, yeah, it was quite a lengthy sentencing. It was Pendergrass, unsafe storage resulting in death.
All right. This is docket 255160 FH and 255735 FH. People of the state of Michigan versus Christopher Regal. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Jacob Sarnes, IV, Assistant Public Defender, appearing on behalf of Mr. Riggle. I am now the attorney record on both files. I've substituted in for Mr. Jackson. Mr. Jackson will be second chair essentially. He's still participating in the case, but I'm on both files now, Your Honor. Thank you.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
You've had an opportunity to speak with your attorney?
Yes, ma'am.
You continue to be satisfied with his representation of you?
Yes, ma'am.
And this is a final pretrial on both files, is that correct? Or are we looking for a global resolution? Because I do have a note that on 255735 FH, we did have a final pretrial, but I think, I don't know, I don't recall.
Yeah, procedurally, this is technically a first pretrial because,
Yeah,
the other file had to be bound over, sent back to district court, Your Honor. They ran a preliminary examination. It was bound over again. We should have the transcripts from that though now. Eventually, if they should be produced shortly. Last time we had an issue with recordings of the transcripts, so they weren't able to generate the transcripts, which is why the case had to go back down for the prelim. Procedurally, Your Honor, there's a lot of motion practice here that needs to be done. It's my understanding that Mr. Pfeiffer, when he gets back, is going to at least at a minimum want to pursue a motion for joinder, and plus I would anticipate pretty standard filings from the prosecutor's office in terms of 768 motions. I'm going to have additional motion practice myself, Your Honor. So because this is technically a first pretrial, I would just request basically a final pretrial and motion hearing date. We have a trial date set for October, Your Honor. So if we could get a date in September and just, try to sort out everything. I'll state, Your Honor, that Mr. Riggle certainly is interested in potentially working out a plea resolution here. He just very strongly disagrees with the offers he's been receiving from Mr. Pfeiffer. And we will continue to try to negotiate in terms of that. So it's possible, Your Honor, that we can ultimately reach a global resolution. I don't think we're that far apart here. I just think respectfully that we can reach an agreement with some additional time as well. Thank you.
on behalf of the people.
Your Honor, I am covering this case for APA Pfeiffer as his wife just gave birth about a week ago, or this week,
Yes.
Your Honor, actually. I would agree that the trial is currently set for October 23rd, and looking at, because Mr. Riggle is in custody, it does appear to be the first case up.
Right.
So I would agree that I do think that a motion, either a motion date / a final pretrial would be best, so Attorney Pfeiffer can talk to the defense and more adequately when he's not having to deal with the birth of his child.
All right, so how about a final pretrial September 23rd at 1 PM? That's 1 month behind the trial, and then you can file any motions or set any other dates you want, or we could use that date for, I don't know how much time we have on that date, but for other motions, but I think September 23rd at 1 for the final pretrial, and then you can work around that. If we need to adjust it, then we'll do that. Hopefully, we don't have to adjust the trial date.
Thank you, Your Honor.
Is that acceptable?
Yes, ma'am.
You get what you need at the jail?
Yes, ma'am.
I know it's not pleasant being in there, but you got your 3 meals and any medication, all that, everything's going okay?
Yes, ma'am.
All right, and I'll see you September 23rd or before, depending on what you all file. If there's anything I need to get involved, and please let me know sooner than later. That's all for this record, thank you.
Thank you.
Yeah, I see Mr. Berry on. You're gonna give me 30 seconds here. Thank you.
See. Sounds good, I'll try and get it done first thing.
Yeah.
Carlos Anthony. I will get to you. Basically, was the only one that's in custody, so the rest I don't need. So I have, I don't think.
Bring Mr. Anthony out.
I have it from there.
Did I bring him up?
Mr. Canyon.
Yes, okay. Can I have Mr. Anthony up, please?
Yeah. Yeah, we just had, for the morning, we just
I
had
mentioned that and they want to.
Carlos Anthony and Lawrence Evans.
He's on Zoom.
Oh, the attorney's on Zoom.
Just 2 for the morning.
It probably is, but I'm just gonna move it up sooner than, I need to know exactly what date, so I need to kind of look. I don't set up more dates. Set up-
This is docket 23-131 FC and 25-4995 FH. People of the state of Michigan versus Anthony, or Carlos Anthony. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barb Buxton on behalf of the people of the state of Michigan in file number 25-4995-FH.
And Michael Doby, Assistant Attorney General for the people in case 23-131 FC.
Good morning, Your Honor. Ronald Berry appearing on behalf of Mr. Anthony on both of these files. I am attending via Zoom and Mr. Anthony is in the courtroom.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
Yes, ma'am.
Is it anything that would interfere in your ability to understand the court or your attorney?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had an opportunity to speak with your attorney?
Yes, ma'am.
All right, and I believe this is a hearing based on the bench warrant. Is that where we are in this?
That's my understanding, Your Honor.
Okay, and I'm looking for the bench warrant. I have the memorandum. I have a bench warrant. All right, so I have a bench warrant that says, as in regard to both files, that says that defendant committed new crime while released on bond, and that would be on both files. And apparently the new charges are still in 54A District Court. He was charged and arraigned on assault with a dangerous weapon, interfering with electronic communications, police officer assaulting, resisting, obstructing, and domestic violence. And he was placed on those allegations in the Ingham County Jail. The allegation is that he committed a new crime or new crimes while on release, and I just, Mr. Berry, waiving further arraignment because we cannot proceed on this because he's presumed innocent until proven guilty beyond reasonable doubt. And I understand there's the Attorney General here as well as the Ingham County prosecutor. So I don't think we can go any farther.
I would agree, Your Honor.
So what's the, are we awaiting preliminary exam or what are we doing?
Yes, Your Honor. The probable cause conference is set for July 31st at 9:30, with the preliminary examination set for August 7th at 9:30.
All right, so I should set, I don't know if you're going to be requesting a transcript or what's the time frame? I could just move all these cases to the first pre-trial on the pending matters, and then we look and see what's going on and do what you all call a global resolution or a global look at these three files? Should we do that?
I'm always okay with an attempt, Your Honor. I think the parties are so far and away beyond any idea of resolution in the two current matters with this court, based upon beliefs of what did or didn't happen, that I don't think this new file really moves the, the position very far, given it's a much less serious offense compared to the ones that he's currently charged with. But I'm always for trying.
All right, so, well, let me ask you this, on the 23 file, are we set for trial?
We are not yet, Your Honor. We need to set a trial date in that.
Counsel, do we have a trial date?
If you recall, Your Honor, I'm preparing an order based upon our final trial conference a couple weeks ago, where the AG's office is to provide the audit trail and all the videos that they have.
And I'm sorry, but that was not the outcome of the hearing 2 weeks ago. 2 weeks ago, the court ordered Mr. Berry to provide a list to me within 7 days of what he believes that he is missing, and then the court would set a hearing based on that. That hasn't happened. The court did not order anything to be produced. We just need to set a trial date and a pretrial date in this.
Yeah, we have different memories of how it happened, and so my understanding was I was to prepare an order under a 7-day rule, and the court would then schedule for an evidentiary hearing on anything that doesn't get produced.
Well,
but I guess I don't know.
Regardless, that wasn't the outcome, and it's been 2 weeks.
Okay. We have a trial date.
Yes, Your Honor, on the 25 matter, that trial date is November 13th, with a final pre-trial date of October 14th. No, sorry, trial November 13th, final pre-trial October 14th.
Okay. Here's the thing. You both have to exchange information. I mean, the defense doesn't have to give their strategy and all of that, but if there's information that people intend on using, it has to be provided to defense. So is there information, has all the information you are intending to use in the case in chief, has it been provided to defense?
Yes, Your Honor.
And Mr. Berry, what are you missing from what you think they have and have not provided?
So I guess, and thank you for the opportunity, I guess that will clarify what the court's position was from last time. So the history on this case is that I was always told that there was no additional police video, there was no additional police video, whatever, right? And then all of a sudden, back in February, I think it was, on the morning of a final pretrial conference, we get, I think it was 4 more police video cameras, which was rather interesting because we were always told they didn't exist.
Okay, I recall that. So have you turned those over?
I have what I have. I did receive a few more body cameras for police videos, but it's only of 4 body cameras on the scene of the location of the party store and talking with the alleged victims at the party store. No other videos. So we don't have any of the dash cameras. We don't have any of the other videos of body cameras when they're out in the field looking for the suspect and apprehending the defendant. But yet we have still image snapshots of a body camera from the apprehension of the defendant, but yet we don't have the body camera for it, which is rather peculiar. So which is why I want an audit trail for any and all police law enforcement video in this case. And this court granted, my understanding of the last time we were here, granted that for me to draft the proposed order for the court to sign. And then if there was an issue with there being a dispute as to whether something does or doesn't exist, then we have an evidentiary hearing regarding it as far as a Brady issue for the failure to provide it.
Did you provide a list
Not-
I'm caught up on all my orders. Did you provide an order?
Not yet, Your Honor. I have to
Why
go
not?
back through, because I have to go back through and name all the officers, and all the officers and look at the police reports to determine specific and compare it to what I have and the audit trails to make sure I'm listing everything.
Is there any reason, does he have to do that? Don't you need to go through and to the various agencies and request the dash cam, the video of apprehension, all of those? I mean, are there things that are just simply not available that you can document?
Your Honor, I have done that. Michigan State Police is the lead investigation on this team. I asked them, and for quite a while, was told that we didn't have any additional video. Everything was turned in. Again, I had a new detective go back and search the archive, and that is where the 4 body cameras were located that were then turned over. As the courts noted, this case is quite old. And again, when we were here 2 weeks ago, and Mr. Berry raised this issue yet again, I asked that I said there needs to be a written motion so that I know what I'm responding to. The court, there's been no motion, there's been no order issued. There's been no list as the court orally ordered Mr. Berry to provide to me so that I have something to respond to, because what I'm responding to is innuendo.
The court literally
so what-
said that it was
wait a
grading the
minute.
motion. We didn't need for me to draft a motion. So it's misrepresentation to the court again.
Okay, well, we're gonna clean this up. I can go back and look at the record. I do so much of this. I remember parts of this for various reasons, but nonetheless. The trial date is going to stand at November 13th. I don't know if we need to move the final pretrial. We can deal with that later. However,
Well, Your Honor, I think the November 13th is the trial for the one with the county, not the one with the AG's office. The one with the AG's office has a separate, or hasn't been set yet.
okay.
That is correct, Your Honor.
Okay, well, why don't we have a date? This is the older file, isn't it?
It is the older, the AG's case is the older filing.
Okay, do we have a date? Can we give them a date?
Does that November 13th date work?
Can we do this one, November 13th? This is the older of the two.
I would say, Your Honor, based upon the track record of providing the discovery and what I still need, I am pessimistic, but I mean, as far as the date itself, I would assume that we could work out if the discovery issues are all worked out by then.
All right, on behalf of the Attorney General, are you available November 13th for trial?
Yes, Your Honor.
Okay, so here's what we're gonna do. The first off will be this 23131 FC on November 13th. If for some reason we get delayed because of discovery matters, then next up will be the 25495 FH. So Mr. Anthony will go to trial one way or the other on November 13th, we hope.
Your
We have
Honor,
to get these cases moving.
I would add just, I do, as often is usually the case, right? I do have another matter that's scheduled for trial that week that starts a couple of days before then. I have no idea yet to know whether or not that will actually go, but if it does, I'll advise the court.
Where is that case?
Eaton County, it's an armed robbery case. It's about a year and a half old, probably, maybe.
Okay, so we can watch that and then we can move this to the 14th or the 15th or the 16th or whatever day we do. We're just gonna keep it within that realm, just keep us posted. So, Mr. Berry, how long is it gonna take you to prepare an order with specificity so that people know what you are looking for? And then if they say it doesn't exist, they will be able to bring it in even if they find it, because that would clearly be a Brady violation. And we'll deal with all of that if and when it happens, I don't know. But so that they don't have to continue going on a hunting mission, because this is an ancient case and there's probably been lots of turnover in the department. When will you have a list done? Do you need 2 weeks, 4 weeks?
No, Your Honor, I'd have it sometime next week. I'm just looking for a day. If I could have till Thursday next week, that should be sufficient for me.
So I'm gonna give you until August 7th. So you get that to me and to council.
Absolutely.
Great.
And just so we're clear, that's as a proposed order, Your Honor.
Yes, well,
Thank
and with a list of whatever you want, I'll sign the order. But I
Thank
want you to give it to me and council can start working on it. I sign things the day I receive them, so even if I'm not in the office, I sign remotely. We're gonna get it signed that the day you submit it. Anything else I can do to help these matters move along?
Not that I'm aware of, Your Honor.
Your Honor, are we addressing bond on these because of these violations?
I'm not, is there a motion for a bond?
I'm asking you that he remains incarcerated and the bond be revoked. I just want to make sure we're on the same page.
We're on the same page. If there's going to be a bond motion, it has to be filed, there has to be a bond report, and with new charges and all this mess, no, there's no bond.
My understanding with the history of this court is, the court would likely address bond after whatever happens at the district court happens.
Exactly, and I need a bond report, so as soon as we figure all that out, it would be too premature at this point for me to look at it, and, I mean, if those charges all get dismissed, that's something, if there's more charges, or if those get bonded over, it's another matter, so I don't have a crystal ball, when I get one, we can do it early, but meanwhile, we're waiting. You know how to find me. Anything else I can do?
No, thank you.
No, from the defense, Your Honor, thank you.
You understand
Yes,
everything?
ma'am, absolutely.
All right, good luck to you, thank you, that's all for this record.